probable cause. All right, Mr. Jackson, I've reviewed the probable cause affidavit. I do find probable cause is the third-degree felony. Schedule bond is $5,000. However, I did notice that you're currently on probation in 19 CF 1764. State.
Your Honor, I'd ask the court to issue a Widman in that case.
All right. Did I get a
Judge, if I may be heard on that?
Yes, ma'am, of course.
Given the recent outbreak in the jail and the fact that
we lost signal for a moment.
Ms. Upson, we can't hear you.
Ms. Upson, are you there?
Okay, Miss, can you hear me now?
Yes.
Okay. Mr. Jackson had finished over half of his probation. In this case, we would ask you to not issue the Widman.
All right.
Judge, if you look at the booking sheet, this is not a criminal offense that involved violence. He willingly stopped. He was respectful with the officer. There's just nothing really aggravating about this particular arrest other than it's another driving. But given the COVID situation in the jail, I think it's appropriate for him to get a bond, if anything.
Well, here's the thing. That is appropriate argument for bond, but I don't see any reason why I should not issue the Widman warrant at this time and initiate the VOP. Having found probable cause for a new criminal offense while on state probation, I think it's my obligation to initiate the VOP at this time. Now, Mr. Jackson, you'll be brought back before me tomorrow afternoon, where Ms. Upson can call back in and then we can discuss bond at that time. But there'll be a first appearance tomorrow on the VOP. All right? All right, so I'll see you tomorrow, Mr. Jackson. Ms. Upson, I assume I'll see you tomorrow as well.
Yes, I'll be there in person. Thank you, Your Honor.
Yes, ma'am. Thank you. No. I'm signing the Widman warrant. There was a $5,000 bond set on the new charge, and the Widman warrant, the VOP, will be set for 24th tomorrow because it's going to be served with this warrant. Yep. All right. Thank you, Ms. Upson. Robert Hoger, is that you, sir? All right, 21 CT 539, 21 MM 370. So you're here for a charge of resisting or obstructing an officer without violence and a charge of DUI. Would you like to have the public defender appointed to assist you, sir? All right, I'm going to appoint the public defender at this time. I have reviewed the probable cause affidavit. I do find probable cause on both counts. I did see, sir, that you have a prior conviction for DUI in 2007. Therefore, bonds are set as follows. Count 1, bond is $2,000. Count 2, bond is $2,000. And sir, as a condition of your release, you may not possess or consume alcohol, and a SoberLink device must be installed prior to your release. It's an alcohol monitor, okay? Okay, so the interlock has to be installed. Not interlock in the car. It's a portable device that you're going to have to blow into in regular intervals to check to see if you have any alcohol in your system, okay? Okay. All right, good luck to you, sir. Okay. William Willis, all right, 21 MM 369. Sir, you're here for a charge of assault. Would you like to have the public defender appointed to represent you? Yes, sir. I'm going to appoint the public defender at this time. Ms. Woodley is standing up. Yes, ma'am.
Do you have a probable cause argument? Can I give you a, like, they don't have a printed Westlaw, so you have your Westlaw?
I do have Westlaw. Give me one moment.
Ms. Woodley, when you give the citation, can you speak up, please?
Please do. Yeah, that works. The microphone's on either side of this little camera here, so. All right.
And plus, when you're speaking to that speaker, it goes to the speaker right above the.
I don't think so. I don't hear anything. Doesn't matter. The voice will carry from there to here. Okay. All right. Yes. Go ahead with the citation, please.
J, its initials JS.
I just need the reporter number.
207, Southern 3rd District, 903.
207 Southern 3rd.
903.
93. JSP State.
Yes,
Okay.
correct. So while you're looking that up, if I could begin my argument.
Go ahead.
For assault, there needs to be a present ability to carry out the threat. And here, he's alleged to have said, quote, "I'm going to kick your ass," walking up to someone. We don't know how close he came. There's no present ability to carry out the threat. The case that I did cite, the court reversed the conviction for assault because I believe it was, and I don't want to misquote what was stated. There was a BB gun. Court said since he never actually drew it, he didn't have the present ability to carry out that threat. And that is analogous to this situation because saying you're going to kick someone's, quote, ass, you have to have the ability, present ability. There's no facts in here or allegations that allege how close he came to this person. We don't know.
What about the allegations that he repeatedly and aggressively approached the victim with his fist clenched?
We don't know how close he got to him. It's not stated in the four corners.
Ms. Karimi?
I don't think that it's important for probable cause purposes as to whether or not or how close he got to the victim. The victim stated that the defendant walked toward him 3 to 5 times, threatening him each time with his, and as the court pointed out, his right hand is clenched in a fist. The victim is trying to walk away from him and he's continuing to walk towards him. I recognize the case that Ms. Woodley cites talks about the BB gun, but that's a completely different set of scenarios. If you're threatening to shoot someone, but you don't produce the gun, of course, you don't have the ability to carry it out. But if your threat is to kick someone's ass and you're walking aggressively towards them with your fist clenched, the state would argue that that is sufficient for probable cause purposes for assault.
I think respectfully, I do think there's sufficient allegations contained here for probable cause for the assault. There's repeated threats to, as everyone stated, victim alleges that he asked him to leave again, began walking towards me with his right hand clenched as a fist, staring at me as I walked away from him. He walked back to his bicycle with trailer, then started walking towards me again, told me he was a Marine. He was going to kick my effing ass. Walked away from him as I was afraid of him punching me and me getting hurt. He walked towards me 3 to 5 times, threatening each time. I think that's sufficient allegations for probable cause for assault.
If I could just briefly respond.
Okay.
But the problem is I can walk up to someone and walk up to them, they can be 100 feet away from me. The difference is, are they 100 feet and if I'm walking up to them versus 5 feet away versus a foot away? That's a big difference. You have to have the present ability to carry out that threat. And we don't know how close did he walk up to that person. We don't know within the four corners of the booking sheet. So that is right there, not enough for probable cause. I
disagree. I think for probable cause. Now, once again, it's an objective standard. Whether a reasonable person under similar circumstances would be in fear is something that can be raised as a defense at trial. But I think under the circumstances, given the allegations contained in the probable cause affidavit, I think there's sufficient probable cause for assault.
I'm objecting for the record because we're assuming that we know how far apart these two people are.
I understand your objection. I've made it ruling. Bond in this case will be set at $2,000. So you may not return to the Walmart at 11225 Tamiami Trail North, Naples, Florida. You may not possess any firearms while this case is pending, and if you have any firearms, they must be surrendered to the sheriff's office within 24 hours of your release.
What is the basis for the firearm? There's no firearm used.
It's an alleged violent offense. There's no firearms used in any of the battery cases that I see. We do the same thing.
I'm objecting to that as well, because there's no firearms used.
I understand. The objection is overruled. All right, good luck to you, sir. All right. Mr. Hollander, who's your client?
Tina Hickok.
All right. Ms. Hickok, good afternoon.
Yeah.
NJC, is there anyone else in the room with her at this point?
The only other one that was gonna be here, the male, he left, Stone Jeffrey, so she's the only one in here right now.
All right.
He's on medical refusal.
He's a refusal. All right, so give me 1 second. So this is Ms. Hickok, 21 CF 341. Ma'am, you're here for a first appearance. I'm about to tell you what you're charged with. Your attorney, Mr. Hollander, is present in the courtroom with me. I don't know if you can see him on the camera.
Yes.
We're then going to discuss whether or not there's probable cause for these charges. If I do find probable cause, we'll discuss conditions of release. If I do not find probable cause, you'll be released on your own recognizance. I will remind you have the right to remain silent. Everything you say is being recorded and may be used against you, okay? All right. Mr. Hollander, you want to announce your presence?
Lee Hollander on behalf of Ms. Hickok.
All right. Ms. Hickok, you're here for the following charges. 1 count of trafficking in methamphetamine, 1 count of possession of methamphetamine with intent to sell, manufacture, or deliver. It looks like another count of possession of methamphetamine with intent to possess, sell, manufacture, with intent to sell, manufacture, or deliver. 1 count of possession of controlled substance. And
What's
1
the
count,
controlled substance, Judge?
probably the bottle of Azalam. And 1 count of possession of paraphernalia.
I'm objecting to counts 2 and 3. You can't break 1 drug into 3 separate counts. Count 1 was the trafficking, correct?
Correct.
Okay.
Which honestly, that's one that I have an issue with because there's no mention of weight anywhere in the PC affidavit.
And Judge, that's why I have the trooper on the line.
Oh, he's here for this case.
Oh, yes,
Yes,
Judge.
Oh, okay. I thought he was for the other one, the DUI SBI. All right. We have a trooper here who's available to testify about that issue. All right. So did you want to provide some testimony at this time?
Sure, Judge, but could you please swear him in?
I'm about to. All right. Sir, would you please raise your right hand? I'll do it because he can see. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, put your hand down, please. State you may inquire, and Mr. Hollander, I'll give you a chance to cross if you wish.
Trooper, can you please state your full name?
Trooper Alex Botello with the Florida Highway Patrol.
And did you arrest someone by the name of Tina Hickok last night?
Yes, I did.
Okay. And during the
What would say? Mr. Hollander was telling you not to say anything. That's what that finger was, ma'am. Okay, go ahead. Sorry.
And during the search of her vehicle, was methamphetamine found?
Yes.
Okay. And did you weigh the methamphetamine?
My partner weighed it while I was at the jail, and when he weighed it, it came out to be 132.5 grams of meth.
I'm sorry, I didn't catch the weight.
132.5 grams of methamphetamine.
Got it. Thank you.
And there was also cash found in the vehicle. How much cash was found in the vehicle?
Yes, $12,378.51 were found in the vehicle. Inside the same bag. Sorry?
Keep going, I'm sorry.
Inside the same bag where the meth was located. There was another bag that contained about roughly $800, $900 in singles, but the rest of that money was located in the same bag with Ms. Hickok's insurance card, her social security card. They were all in the same bag.
And in this case, was a field test used or was there another test used to identify the methamphetamine?
We have a device called True Narcotics Analyzer, where it has a laser and analyzes the material, the substance, and it came back to methamphetamine.
Okay. And the statement that you mentioned at the end of your report, where Miss Hickok is making a phone call in the back of your patrol vehicle, your report reads that she said, "They're going to find the stuff that you wanted me to take to Timmy's in the car." At the point that she makes that statement, had you even started searching her vehicle?
No, we have not. We were waiting for another trooper to arrive to assist as well. And that was at 1:43 p.m. and we had not entered the vehicle at that point.
All right, Judge, I have no further questions.
May I ask a quick question? There appears to be 2 separate counts for possession with intent to sell, manufacture, or deliver. Why is that divided into 2 counts?
So one was possession and the other one, I believe, was intent.
Okay.
That's why it's like that.
Okay. Mr. Hollander, any questions?
Yes. Which trooper were you waiting for?
Trooper Valdez. He's not a K9 officer. He's another member of the unit. I'm in a spare vehicle and I don't have a cage. So our concern was if we left them unattended, they can get in the driver's seat, possibly. So one trooper was more focused on the vehicle, my patrol vehicle, and myself and Valdez searched the vehicle.
Oh, okay, but you wait. Who was the second trooper then?
That's Trooper McCormick.
But Valdez was the K9 officer.
No, Trooper McCormick is a K9 officer, and Trooper Valdez is a felony officer.
All right. When you weighed the methamphetamine, did you just pour the powder out on a scale?
No, I was not there for that. But we do not do it like that. We leave it inside the bag, and we have a scale in our station, and that's how we weigh it.
So the weight included the container?
No, it was a Ziploc bag.
Right. So the container being a Ziploc bag, yes?
Yes, sir.
All right.
What time did you pull them over?
Objection, Your Honor. We have the report. This is beyond the scope of direct.
I don't have
I'll give you a little bit of leeway, Mr. Hollander, but this is just to determine probable cause.
I got it.
All right. Go ahead, sir. Trooper, go ahead and answer.
Trooper,
I pulled them over at 1:30 p.m.
Okay. Judge, again, I'm no further questions.
All right. Thank you, Trooper. All right. Well, that answered my question on count 1. That was really the issue. So let's do these one at a time. I do find probable cause on count 1 for the trafficking charge.
And I'm going to ask the court to minimal bond $10,000. She's a lifelong resident of Everglades. I don't believe she has any FTAs to her record.
Well, there are
like I said, I don't get to see that.
You don't get the NCIC, but this is it. There have been some failures to appear in her past. Yes, sir.
I was asking for 10 or 15,000. She's a lifelong resident. She's not going anywhere. Her family is all here. Here in North Florida, and just asking that you reduce. Oh, and I'm moving to find no probable cause for 2 and 3 because they're part of 1.
All right. All right. So let's do this. I do find PC count 1, counts 4 and 5. State what is your arguments for 2 and 3?
4, 5, 2 and 3 are the possessions with intent and deliver.
Correct.
Well, Judge, I think there's at least probable cause for one of those. She's found with 132 grams of methamphetamine in her car. She makes a statement how she's driving it to someone's house, and she has over $12,000 of cash in her car. And to go back to the trafficking count, Judge, I just want to make it, just so the court is, I'm sure you're aware, but just to state it, grams, and it's a 7-year minimum mandatory and a $100,000 fine.
Yeah.
So,
I'm sorry.
I'm sorry. I cut you off, and then Mr. Hollander cut you off. We both cut you off. Please continue, and then Mr. Hollander, I'll give you a chance. Sorry.
So the trafficking's a 7-year min-man with a $100,000 fine. I would argue there's probable cause for at least one of the possession with intent to sell based on what I previously said. The amount, she's driving it, she makes the statement that she's taking it to someone, and she has over $12,000 in cash in the car.
All right, Mr. Hollander, go ahead.
Even with those, Judge, the 7-year min-man is based on the total package weight. Nobody seems to know how much methamphetamine there was.
It's
very big.
It's the whatever it's mixed with. So they don't have to. I don't have to isolate only the methamphetamine atoms of whatever's contained in the substance.
I'm talking about the amount minus the Ziploc bag.
Let's say it's a very heavy Ziploc bag,
okay,
and it's a few grams. We're still well north of the threshold for that methamphetamine. The threshold, I believe,
it's 28 grams, more, but less than 200 grams.
It's not. It's not a 100-gram baggie.
That'd be a heavy bag.
It'd be a very heavy bag.
All right, Judge. Like I said, she's a lifelong resident.
I understand.
She's not going anywhere. She's not a flight risk. She's not a threat to the community. So I'm asking for minimal bond so she can post it, get out, and go back to working at the beach bar down in Everglades City.
I understand. All right. I don't.
Oh, I'm still.
Oh, yes, sir. I'm sorry. Please
arguing
continue.
on 2 and 3 that.
Yes, sir.
Those are part of, contained within 1.
I agree with you in part. I do find probable cause on count 2. I would do no PC on count 3 because it really is the same charge, literally the same charge. But there are different elements to the trafficking and to the possession with intent. They both have possession, but one is, there's the element of weight, the other one is the intent portion. And they're varying elements. One is not a lesser of the other. They are not one and the same. And at least at this stage, right, there's nothing prohibiting stage. I understand she may not be able to be convicted of both offenses, but there's nothing stopping the state from pursuing both charges simultaneously in the course of the prosecution. With the understanding that it may be double jeopardy to convict on both, they can pursue alternative paths at this stage.
I understand.
So I do find PC on the second count. Then, I'm referring to 903.046. Looking at subsection D, 2D, defendant's past and present conduct. As hinted to, Mr. Hollander, I've looked at your client's criminal record and it is extensive, going back decades. There have been prior failures to appear. I've seen criminal record going back into the 80s with prior similar offenses. The court should also consider the subsection H, the street value of any drug or controlled substance connected to or involved in a criminal charge. The court is well aware, that amount of drugs carries a substantial street value. Therefore, bond on count 1 is $100,000. Bond on count 2 is $25,000. ROR count 3, 5,000 count 4, 2,000 count 5. All right, ma'am, Mr. Hollander is going to be reaching out to you, okay?
Can I say something?
No.
Deputy agent, I was on crack for 26 years and I didn't have nothing.
What does no mean?
Ma'am, your lawyer is trying to help you by telling you not to talk right now. Thank you, Mr. Hollander. Have a good afternoon.
May I be temporarily excused? I have a plea in front of the court.
Yes, sir. You've got a few minutes.
Kearney.
Yes, sir. I'll wait for you.
I'll be out in the hall, or I'll be trying to talk to Judge Foster. Thank you.
Thank you, sir.
Your Honor, could the trooper sign off?
Yes, please. Thank you, Trooper. Have a good afternoon. Stay safe.
Thank you, Your Honor. Thank you.
All right. All right. So I had Mr. Stone, who refused to appear. Was Mr. Stone physically unable to appear, or did he just not want to be here?
He actually was in the room before we got started. He filled out a public defender form with me, but he's in a lot of pain, so he wanted to go back.
All right, that's no problem. I'm going to go ahead and proceed in his absence because he did apply for the public defender, so I'm going to appoint the public defender to represent Mr. Stone at this time. Mr. Stone is charged under Capias, 1 count of DUI with serious bodily injury, 1 count of DUI with damage to person or property, 1 count of leaving the scene of a crash, hit and run, failure to remain with serious bodily injury. I have reviewed the probable cause affidavit. Ms. Woodley, you're gripping the armrest.
The only thing I was going to say is I don't have a probable cause argument to ask for a schedule.
All right. I do find probable cause on all 3 counts. State, did you want to be heard on conditions of release?
Yes, Judge. Where is the case? I have to find it. I just want to make the court aware that he does have prior DUIs.
Back in the early 80s, I saw.
Where is his driving record?
He has 2 prior.
He has, yes, 1 in 1981, 1 in 1983. He has a DWLSR from 2013. He has prior, his license has been suspended for a drug offense. You know, the victim suffered serious injuries in this case. He's currently undergoing physical therapy and working with an infectious disease specialist. So I would ask the court for heightened bonds. This defendant is a danger to the community and the roads of Collier County.
Do you have a specific request in mind, or are you just generally asking for?
I would ask for $25,000 for each of the felonies and $5,000 on the misdemeanor.
All right, Ms. Woodley, would you like to be heard again?
All of his criminal history is very, very old, to say the least, and that is an extremely high.
Well, the driving history is old, not his criminal history.
As far as what's related to DUIs, that's from, I believe, or at least my search.
Because, for example, while those DUIs are back in the 80s, there was possession of controlled substance conviction where he served a year and a day in state prison as recently as 2015. It seems to be the most recent entry, so about 6 years ago. And the allegations is that the controlled substance that he was under the influence of, it wasn't alcohol, it was
drugs.
Drugs.
Not a flight risk. I didn't see any FCAs on his record, and that does say a lot about whether someone's going to come back to court And without seeing, and I'm sure Ms. Queen will correct me if I'm wrong about FCAs, but I did not see any on his record, and for that reason, not seeing to sit with the scheduled bond.
All right. On count one. Bond on count one is 15,000. Bond on count two is 5,000. Bond on count three is 15,000. All right. Next, I've got Lance. Is it Levy? Lance Levy? All right. This is 21 CF 338. Good afternoon, sir. Sir, you're here for a violation of no contact order under 921.244. Sir, did you wish to have a public defender appointed at this time?
No.
Okay, you're going to represent yourself?
Well, I have an attorney, but I don't think she knows what's going on.
Well, would you like me to bring you back tomorrow to have your attorney present?
No, that's fine.
All right. So you want to proceed without a lawyer today?
Right.
Okay. I reviewed the probable cause affidavit and I find no probable cause.
Judge, I understand that, but under Florida statute 903.047, the court could revoke a bond. He is facing attempted second-degree murder charges in 20 CF 1088. This is a violation of that no contact order in that case. So I'd ask the court to revoke in that case.
I think that motion needs to go before the trial judge, because not that I wouldn't grant it if I was a trial judge, but I'm not. So I don't know, is this Judge Foster or Judge Money's case?
Foster.
That motion needs to go before him. All right, OR in this case. Thank you, sir. All right. Christopher Michael Moreland. Good afternoon, sir. Sir, you're here for a VOP warrant out of Lee County. Would you like to have the public defender appointed today, sir?
No, I actually have an attorney.
Okay. All right.
I actually flat out discharged yesterday. It was Judge Foster, Iron Stern, and upon my release, they hit me with this warrant.
Who is your lawyer on the case, the other case?
Here on the officer.
Oh, she was just here. She will be here tomorrow for another matter. Do you want me to continue this to tomorrow so she can be present?
I guess I don't see why I was.
That's fine. I mean, it's up to you, sir. I can go forward today, or if you want to have Miss Upson present, I can see you tomorrow when I know she'll be here.
We go forward tomorrow.
You want to go forward today?
Yes.
All right. All right. I said I've confirmed that Judge Porter did issue that VOP warrant. He wishes that you be held without bond. I do find probable cause. Bond is set at no bond. All right. Good luck to you, sir. All right. All right. Benjamin Stafford. Oh, okay. Well, that's who I've got next. Okay. And then
we're going to stay with IVC for Ms. Cardenas.
Are we going back over to NJC at all?
Yes.
Okay.
The last. Hello, sir. Is this Benjamin Stafford?
I'm sorry, what was that?
You have a Benjamin Stafford there?
I am not. We're going to have a group of Cardenas, Jose.
All right, you got the right person, but do you, for a plea, do you have a Benjamin Stafford in your jail?
I will check one second.
Okay.
He's on our list.
He is.
Benjamin Stafford is being brought down right now.
All right. Can I switch over and address Mr. Godinez's case because he's here? Can we go ahead and do the plea now?
Sure.
It works for you?
Yes.
Okay. Let's go ahead and do that since he's here.
Christina Woodley on behalf of Jose Luis Godinez, and he does require the use of a Spanish interpreter, 21 NM65.
Señor Godínez, yo soy Cristina Woodley, la abogada que lo representa, y usted va a usar los servicios del intérprete de español.
He would like to withdraw his previous plea of not guilty and enter a plea of no contest to the following agreed upon terms.
Él está cambiando su antigua declaración de no culpable por la de no lo disputo ante los términos que siguen.
The adjudication of guilt,
Sería una sentencia que se le impondría
60 days in jail, credit all time served.
60 días en la cárcel, crédito con todo el tiempo que ya ha cumplido,
Court costs, cost of prosecution, and public
gastos del
defender fees.
tribunal, gastos del procesamiento y gastos por los honorarios del abogado de oficio.
State, can you confirm that those were the terms?
Adjudication, 60 days jail, all credit, court cost, cost of prosecution.
And he has more than those 60 days already?
He does.
Okay.
Sería más de 200, sí, ya lo tienes.
All right. Mr. Godinez,
Señor Godínez,
do you wish to accept the plea offer that's just been stated?
¿quiere usted aceptar la oferta que se le ha extendido?
Sí.
Yes.
Please raise your right hand.
Por favor, levante su mano derecha.
Do you solemnly swear or affirm the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
Juro que el testimonio de la continuación representa la verdad, toda la verdad y nada más que la verdad. Sí o yes?
Sí.
Yes.
All right. Sir, the state attorney is going to ask you a few questions.
La fiscal le va a hacer unas preguntas, señor.
Sir, could you please state your full name?
Señor, diga su nombre completo.
José Armando Luis Rodríguez.
José Armando Luis Godínez.
You've been charged with resisting an officer without violence.
Resistencia sin violencia es el cargo que se le imputa.
Do you understand that the maximum for that charge is 1 year in jail?
Entiende que el máximo de esta sería un año en la cárcel.
Sí.
Yes.
To that charge, how do you wish to plead? Guilty, not guilty, or no contest?
¿Cómo se declara ante este cargo? ¿Culpable, no culpable o no lo disputa?
No disputo.
No contest.
Have you reviewed a plea form?
¿Revisó usted el formato de declaración?
No disputo.
No contest.
I've reviewed a version of the form with them.
All right. Sir, were you given a piece of paper that talked about your rights in a criminal case?
Señor, ¿no le entregaron una hoja que habla sobre sus derechos constitucionales?
Sí.
Yes.
All right. Did you get to go over that paper with your attorney?
¿Usted revisó esto con su abogado?
Sí.
Yes.
Did you understand it?
¿Lo entendió?
Sí.
Yes.
All right, please continue.
Are you entering into this plea because you believe it is in your own best interest?
¿Usted se está declarando así porque cree que esto es lo que más le conviene hacer?
Sí.
Yes.
Are you currently under the influence of any drugs or alcohol?
¿Está en este momento usted bajo los efectos de drogas o alcohol?
No vamos por nada.
No, not at all, nothing.
Are you currently taking any medication?
¿Está tomando algún medicamento usted en estos momentos?
No, también.
No, no.
Do you suffer from any mental illnesses?
¿Usted sufre de alguna enfermedad mental?
Ninguna.
No, none.
Have you discussed the terms of this plea agreement and the rights you are giving up with your attorney?
¿Ha analizado con su abogado los términos de este acuerdo negociado?
Sí.
Yes.
Are you satisfied with your attorney's advice?
¿Está usted satisfecho con los consejos que le ha brindado su abogado?
Sí.
Yes.
You understand that if you are not a United States citizen, you may be subjected to removal or deportation as a result of this plea.
Entiende que si usted no es ciudadano de los Estados Unidos, como consecuencia de esta declaración, un proceso de deportación se puede iniciar en su contra.
Sí.
Yes.
Do you understand that if you were deported as a result of this case, it will not be a basis to withdraw this plea?
Si usted se le deportase como consecuencia de esta declaración, no podría ser la base para retirar esta declaración, ¿entiende?
Sí.
Yes.
Do you need any additional time to discuss any of this with an attorney?
¿Necesita usted tiempo adicional para analizar esto con un abogado?
No.
No.
Your Honor, the state tenders the plea.
Llegamos al acuerdo, su señoría.
IJC, do we know if this gentleman's detainer from ICE is still in effect?
I do not have information from me, sir.
¿Alguna información sobre la detención por inmigración de este señor? No tengo información, su señoría.
All right. All right. I have reviewed the probable cause affidavit.
Yo revisé la declaración jurada de las razones fundadas.
And I do find that there is a sufficient factual basis in venue.
Existen suficientes bases y juzgado.
I have considered the colloquy.
Y he tomado en cuenta la introducción.
And find the plea to be freely, knowingly, and voluntarily entered.
Libre y voluntaria ha sido esta negociación, esta declaración.
Therefore, I will accept the plea.
Aceptamos, por lo tanto, esta declaración.
And impose sentence as follows.
Y la sentencia que impondría es la siguiente.
For the charge of resisting an officer without violence.
La resistencia a un oficial sin violencia.
Adjudication of guilt.
Se le impondría la sentencia.
$220 in court costs.
$220 gastos del tribunal.
$50 public defender fee.
50 por los honorarios del abogado defensor público.
$50 cost of prosecution.
Gastos del procesamiento 50.
60 days in the Collier County Jail.
60 días en la cárcel.
With credit for all time
Se
served.
le acredita todo el tiempo que ha cumplido.
And I think I'm required, because as far as I know, there's still an immigration detainer, to reduce the sentence by not more than 12 days to facilitate a transfer to immigration authorities.
Teniendo en cuenta que existe una orden de migración, la sentencia se reduce a 12 días para facilitar el traslado del señor a un centro de inmigración.
And we'll see how.
Your Honor, I just confirmed that he does have an ICE detainee, so.
Okay. What's that? You vetted that? All right. All right, 90. Yep. 90 days to pay. Good luck to you, sir.
90 días para hacer los pagos. Buena suerte, señor.
All right. I think so. All right. Is this Mr. Stafford?
Yes.
All right. Good afternoon, sir.
Good afternoon, Your Honor.
This is 21MM371. So you're here for an alleged violation of conditions of pretrial release, specifically a violation of the no contact order issued at first appearance on an underlying battery charge. Did you wish to have the public defender appointed? Actually, let me ask you a question. Do you already have a lawyer on your other case?
I do.
And who is your lawyer on that case?
Chris Brown.
Chris Brown. All right. I can offer you a couple of options, sir. If you want, you can try to reach out to Mr. Brown and see if he wants to represent you on this case. I can bring you back tomorrow. You can go forward with the public defender if you wish, or you can represent yourself today. What would you like to do?
What is the actual proceeding today? Is this an arraignment?
It's just the first appearance, just for me to determine whether or not there's probable cause and to set a bond.
I'll represent myself at the moment.
Okay, fair enough. All right, I reviewed the probable cause affidavit. I do find probable cause. Bond on this matter is $5,000. You may not have any contact with the alleged victim. And it looks like state bond on the battery was previously revoked because of a similar charge. Is that correct?
Yes, Judge, but I'm asking the court to revoke the bond on that similar charge, 21 MM26.
All right. That motion is granted.
Wait, this is
The charge, sir, is alleging that you violated the no contact order from the battery charge.
on January, correct?
I'm sorry?
On January 4th?
I believe so. Let me double check. The original contact order was issued on January 5th, is what the incident is alleged to have happened on the 4th. The original no contact order was issued on the 5th of January. All right.
The original no contact was issued on December 21st, approximately.
Oh, hold on. We have the wrong charge. There it is. Let's see. The original no contact order was issued on December 20th. Sorry. The bond is being revoked on the case where there was the order issued on the 5th of January.
Right, so can you reinstate that since it's already been 60 days and I've been here for 60 days since that bond's been revoked now. This is the first appearance. Can you please reinstate the bond on the
No, sir.
charge?
No, sir. I'm not in a position to do that. You can talk to Mr. Brown, who can file a motion with the presiding trial judge on that matter to address that issue, but I'm not in a position to do that today, okay?
So this is considered an arraignment or 24-hour? What?
This is a first appearance, sir. You're charged with a new crime for violating that original no contact order.
New crime is, when was the charge issued? Today?
Yes.
What?
Sure, it's alleged that moment. The violation in this case is alleged to have occurred on March 1st. That's the allegation.
Any contact with them? I've been in jail.
Sir, that's the allegation. If you find probable cause, you should discuss it further with Mr. Brown, not with me. All right?
Do I get a police report or anything?
Yes. Yes, you will. All right? Yeah, there's a report. You will be able to get a copy of the report that outlines all of this. All right?
Yeah.
All right. Good luck to you, sir.
I'm JC. Thank you for getting this established so quick.
All
Have a
right.
good day.
Thank you. All right. Going back, where are we at now?
I am down this morning.
All right. Oh,
I gotta go back to third bro.
do you know what happened with the two gentlemen from Pinellas County? Were they finally transported?
They were.
early this morning.
Okay, but I don't need these. Thank you.
Your Honor?
Yes.
Hi. If I could request that you recall a case that you continued. I was unaware that it was set for today's 24's.
Oh, sure. Which case are we talking about?
It was Benjamin Forget, 20 CF 782.
I knew I pronounced that.
Forget, yeah.
Yeah, I know. What did I, let's see, what did I do with Mr.
You could, from what I understand, you continued it to tomorrow's 24's. However, I did file a motion to set bond. I wasn't aware it would be on your docket today, and I would request that you review that. And if you could recall him, I know he's in the jail, eager to.
I don't know if he'll be able to move or not.
Could you please bring up 4J again? What was the name? Benjamin Forget.
Okay.
You can just bring them eventually.
Thank you very much.
Sure.
And Your Honor, I did just file this, but I have confirmed it's hit the docket. So if you pull up the docket, it's the newest motion.
State, do you have a copy of the motion?
I do, Judge, but
Well,
I do, Judge. I have a copy of the motion.
okay. All right.
We're just asking for a bond.
Well, let's bring him up.
Thank you.
Let me go ahead and address a couple other cases first.
Sure.
Take a moment for them to get them.
Thank you.
Mr. Hollander is waving at me. Oh, he's walking up? All right. Recalling Benjamin Thomas. Sir, I'm going to ask you. Wait, hold on, he's almost there. Sir, your lawyer is on Zoom with me. She signed in after I talked to you, but she wanted me to readdress the case because she's here now, okay? All right, so my first question is, how do you pronounce your last name?
It's pronounced Forget.
It is pronounced Forget. All right, I won't mess it up again. All right. So like I said, your lawyer is present. Ma'am, for the record, please announce your presence.
Maria Bryant on behalf of Benjamin Forget.
All right. Sir, you're here on an alleged violation of state probation. I had read the allegations to you previously. I do find probable cause. So go ahead with your argument for bond.
Your Honor, this is a violation for allegedly testing positive for marijuana without a prescription. Mr. Forget has a prescription. I have attached to my motion proof of that prescription, which has been in place for over a year, or just about a year, coming up on renewal and has been renewed. So he has a prescription. The only allegations are that he tested positive and therefore was in possession of marijuana, again, without a prescription, but he has a prescription. We are simply asking for a bond today. We can address this before the court in an evidentiary hearing, but given the four corners of the warrant, specifically asserting that he does not have a prescription for this controlled substance, and given the proof of the prescription that he does have, I'd like to request a reasonable bond.
Okay.
Is it my turn?
Yes, please.
Oh, okay. Judge, the state would object to the court setting a bond. Judge Foster signed this warrant February 24th, 2021. He signed it no bond. I would ask the court to maintain Judge Foster's no bond warrant. And according to Ms. Cunningham, he is scheduled to go in front of Judge Foster on March 10th. So there would be an opportunity in the very near future for defense counsel to make this argument in front of his assigned judge.
And if I may respond respectfully, Your Honor, Mr. Forget is in mental health court. He is in AA. I've included this in my motion, but he is attending meetings, attending therapy, has gainful employment that he will lose should he have to spend a full week in jail. And I am happy to address this before Judge Foster. However, since he is here and it is clear on the face of the warrant that he is being alleged to have partaking in something he has a prescription for, and I have shown proof that he has a prescription. The warrant on its face is legally insufficient, and I request a bond.
All right, given what's being presented before me, I am showing that there is a, hold on a moment.
I had to print it offline, so you got to scroll down. Apologies.
Okay, I'm looking at it. Just reading all of it. Give me just a moment. All right, I'm showing a printout presented by counsel for Mr. Forget off the Florida Health website, which is the Medical Marijuana Use Registry, indicating that there is an active prescription card for Mr. Forget for medical marijuana.
Well, Judge, it's not just the card. They have to have also an active prescription at the same time. It's like a double, you know, this just says that his
reflected in what I have provided.
I think under the circumstances, Judge Foster will agree with what I'm doing. I'm going to go ahead and set bond of $5,000.
Thank you.
Judge, I'm sorry, 1 second.
Sir, this doesn't make the VOP go away by any means. You're still going to have to address this, and if your lawyer is unable to, sufficiently convince the judge and/or the state that you did not violate your probation, this will still go forward. But I've been shown sufficient proof at this time that I feel that the setting of bond is appropriate.
Thank you.
All right, bond will be set at $5,000. All right, good luck to you, sir.
Thank you, Your Honor.
Now, that being said, I made a giant mess of this order because I originally crossed through it. I did one thing, I'd have crossed through that, go back to it. So I hope this is clear what I'm doing. But there's a finding of probable cause in the setting of bonds. And I'm going and state, I'll tell Judge Foster myself what I did, and so he can be mad at me. You want me to?
You can call Miss Cunningham too.
I will. I was actually planning on talking this afternoon anyway, so they can both be mad at me.
Do we have any more pleas, Judge?
I think we have two more. Mr. Hollander. Yes, we're done with the first appearance docket. Yes, we're done with the first appearance docket. Yes, have a good afternoon.
Chaz Tierney, Judge.
Okay.
20 CT 1969.
I couldn't hear the case number, I'm sorry.
20 CT 1969.
Thank you.
All right, Mr. Tierney, good afternoon. So your lawyer, Mr. Hollander, is present in the court with me, and we are set for a plea today. Is that correct?
Yes, sir.
All right. What are the terms of the plea, please?
Adjudication of guilt, $1,000 fine, all costs, 12 months probation, no early term, 12 months driver's license suspension, DUI school appropriate phase, substance abuse evaluation, follow recommendations, random testing, no alcohol, possession or consumption, 10-day vehicle impound, victim impact panel, and 50 hours community service.
All right.
And Judge, I would ask that the judgment also reflect that he has 11 days of credit.
All right. 11 days credit. 11 days credit for time served. All right. Sir, do you want
the 12 months probation here?
Oh,
Yes.
Yeah.
Right. Okay. All right. Sir, do you want to accept the terms of that plea at this time?
Yes, Your Honor.
All right. Please raise your right hand.
You solemnly swear affirm the evidence you shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Okay.
You can put your hand down, please. The state attorney is going to ask you a few questions. Go ahead.
Sir, could you please state your full name? You've been charged with driving under the influence. Do you understand that the maximum for that offense is 6 months in the county jail?
Yes.
To that charge, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
No contest.
Have you reviewed a plea form?
Yes.
Did you understand all of the rights listed on that form that you'll be giving up by entering your plea today? Did he say yes?
He said yes.
Are you entering into this plea because you believe it is in your own best interest?
Yes.
Are you currently under the, sorry.
He said yes.
Are you currently under the influence of any drugs, alcohol, or medication?
No.
Do you suffer from any mental illnesses?
No.
Have you discussed the terms of this plea agreement and the rights you are giving up with your attorney?
Yes.
Are you satisfied with your attorney's advice?
Yes.
Do you understand that if you are not a United States citizen, you may be subjected to removal or deportation as a result of this plea?
He said yes.
Do you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea?
I do.
And do you need any additional time to discuss any of this with your attorney?
No, I don't.
Do you understand that driving under the influence is an enhanceable crime, meaning if you commit this crime again in the future, you could receive more jail or prison time, a higher fine, or a longer driver's license revocation period?
Yes, I do.
Do you understand that this conviction could serve as the basis for an additional suspension of your license by the DMV?
Yes, I do.
Your Honor, the state tenders the plea.
All right. I reviewed the probable cause affidavit. I do find that there is a sufficient factual basis in venue. Consider the colloquy and find the plea to be freely knowingly and voluntarily. Therefore, will accept the plea and impose sentence in a moment. As soon as you're ready. All right. For the offense of DUI, first offense, adjudication of guilt, $388 in court costs, $1,000 fine, $50 public defender application fee, $50 cost for prosecution. 12 months license revocation, 12 months probation. Special conditions of probation are as follows. You must attend and successfully complete the DUI school appropriate phase and the victim impact panel. You may not possess or consume any alcoholic beverages, no entering bars, taverns, saloons, pubs, lounges, or package stores, or any other establishment whose primary purpose is to sell alcohol. No alcoholic beverages in your residence. You must undergo a substance abuse evaluation and follow any recommended treatment, and you're subject to random breathalyzer and urinalysis at your own expense. You must perform 50 hours of community service. You're agreeing that there'll be no early termination of probation, and you are to be given 11 days of credit of time served towards your probation. Did I miss anything?
The 10-day vehicle impound?
Oh, there it is. And 10-day vehicle immobilization.
Okay. Yes, Judge, that's all.
All right, thank you. Thank you, Mr. Hollander. Good luck, sir.
Thank you.
You know, Mr. Hollander, you've been doing this a long time. I don't know how many times you can tell somebody to not talk. You know, they're not going to listen to you.
No.
Understand the end of the O.
Are you getting? No, I have one more.
Oh.
But if you want to wait to talk it, that's fine. What's that?
He had a great defense.
Oh, hold on. Let's wait. We're still on the record. Let me take care of this film, and
He didn't want me to just want to play it.
which is the exact opposite, if you remember, of Mr. Julio.
Oh,
He
God,
had,
yes.
he had no defense, and he wanted a trial.
Yeah. I mean, I still never figured out.
Mr. Hollander and I,
He wanted the free medical for his cancer.
we went to trial on a racketeering case where the underlying predicate offenses were there's an undercover agent selling him stolen property. And at one point on video, the cop says to him, "Sir, you understand everything I'm selling you is stolen?" He goes, "Yeah, that's fine." And he wanted a trial on that. It didn't go well.
No, I never did understand. I guess, but I never understood why.
Take care, Mr. Hollander.
Have a good day, Judge.
All right. This is 20 CT 2222, Gilmer Camos Salez. I'm so sorry I mispronounced the name. Oh, right. I did have two left. Yes, sir. I did have two left. Thank you. All right. Is this Mr. Camos Salez?
That is, Your Honor.
All right. Thanks, sir.
Your Honor, there is also another case that we were going to lead out today as well.
Oh.
Mr.
All right. Do you have that case number?
Yes, it was 21 CT 490. That's the driving license suspended.
All right. Give us just a moment.
Thank you for taking it.
No problem. We thank our clerk for putting it on there.
Thank you, Madam Clerk. You have a copy of it.
Yes, please. Thank you. All right, it's added. What are the terms of the plea, starting with the DUI charge?
Your Honor, this is going to be a change of plea to no contest. It's going to be an adjudication of guilt, $500 fine, 12 months of probation with no early termination, 12 months driver's license suspension, DUI score, substance abuse evaluation with follow-up treatment, no alcohol possession, 10 days vehicle impoundment, victim impact panel, 50 hours community service, court cost and cost of prosecution.
There's also random testing, Your Honor.
Okay.
And Your Honor, if I may just fire real quick.
Yes, of course.
Mr. Connell, can you hear me?
Yes.
Are you still working? Are you still working in a restaurant?
I'm sorry.
Are you still working as a server in a restaurant?
I am.
Your Honor, I would ask for an exemption for
No problem.
Thank you.
All right, anything further on that count?
No, Your Honor.
All right, then on the DWLS?
And the terms and conditions are adjudication of guilt, credit time served, court cost and cost of prosecution.
All right. All right, State, can you confirm that oh, yes, ma'am.
Judge, I'm just going to check his credit. Sorry, I'm still getting used to that.
Yeah, me too. All right, so, but otherwise are the terms correct?
Yes, Judge.
All right. And sir, do you want to accept the terms of that plea agreement?
Yes.
All right, please raise your right hand.
Do you solemnly swear or affirm the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down, please. State whenever you're ready.
Judge, his credit is 7 days, so I'd ask that the judgment reflect that.
No problem.
On the DUI.
Probation.
Towards probation, correct.
Sir, could you please state your full name? Okay, in 20 CT 2222, you were charged with driving under the influence. Do you understand that the maximum for that charge is 6 months in the county jail?
Yes.
To that charge, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
And in 21 CT 490, you were charged with driving with a suspended license. Do you understand the maximum for that charge is 60 days in the county jail?
Yes.
And to that charge, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
Have you reviewed a plea form?
Yes.
And did you understand all of the rights listed on that form that you'll be giving up by entering this plea today?
Yes.
Are you entering into this plea because you believe it is in your own best interest? What did he say?
He said yes.
Are you currently under the influence of any drugs, alcohol, or medication?
No.
Do you suffer from any mental illnesses?
Do you suffer from any mental illnesses, sir?
No.
Have you discussed the plea agreement and the rights you are giving up with your attorney?
Yes.
Are you satisfied with your attorney's advice?
Yes.
Do you understand if you are not a United States citizen, you may be subjected to removal or deportation as a result of this plea?
Yes.
Do you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea?
Yes.
Do you need any additional time to discuss any of this with your attorney?
Yes.
You need more time to talk to your lawyer?
I'm sorry, what was that?
Do you need more time to talk to your lawyer? Okay. You said no.
Do you understand that driving under the influence and driving with a suspended license are enhanceable crimes? Meaning if you commit these crimes again in the future, you could receive more jail or prison time, a higher fine, or a longer driver's license revocation period.
I understand.
Do you understand that these convictions could serve as the basis for an additional suspension of your license by the DMV?
Yes.
You said yes.
All right, the state tenders the plea.
All right, I've reviewed the probable cause affidavit. I do find that there is a sufficient factual basis and venue. I've considered the colloquy and find the plea to be freely, knowingly, and voluntarily entered. Therefore, I will accept the plea and impose sentence as follows. Starting with the DUI charge, which is 20 CT 2222. Adjudication of guilt. $388 in court costs, $500 fine, $50 cost of prosecution. 12 months probation. 12 month license revocation, 12 months probation. Special conditions of probation are as follows. You must attend and successfully complete the DUI school appropriate phase in the victim impact panel. You may not possess or consume any alcoholic beverages. No entering bars, taverns, saloons, pubs, lounges, or package stores, or any other establishment whose primary purpose is to sell alcohol except, except for employment purposes. You may not have any alcoholic beverages in your residence. You're subject to random breathalyzer urinalysis at your own expense. You must attend a substance abuse evaluation and follow any recommended treatment. You must perform 50 community service hours. You must immobilize the vehicle for a period of 10 days. You're agreeing that you will not petition the court for any early termination of probation, and you are to receive 7 days of credit for time served towards probation. And then did I get everything on that count?
Yes, sir.
All right, then in 21 CT 490, for the charge of driving license suspended, adjudication of guilt, $220 in court costs, $50 public defender application fee, $50 cost of prosecution, time served, 90 days to pay any financials. And we did cover, because this is essentially 2 strikes, the possibility of a habitualization. Let's discuss with them. Very good. All right. Good luck to you, sir. Take care.
Thank you.
All right. Thank you, sir.
You have a wonderful day.
You too.
Take care. Thank you.
Take care, sir. All right. I do have one other. And it is Mr. Rodolfo Gutierrez, 20 CT 2573. Mr. Gutierrez, good afternoon.
Good afternoon, Your Honor.
Sir, you're here for a pretrial conference. It was originally scheduled for this morning, but because you were in custody, I had it reset for this afternoon. Sir, you're charged with DUI, second offense. with a blood or breath alcohol level above a 0.15. My first question is, would you like to have a lawyer help you with your case?
I was in the process of getting a lawyer,
Hold on, the mic cut off. So you said you were in the process of hiring a lawyer. Who are you going to hire? You want Mr. Miller? All right. Would you like me to give you some time to try to hire Mr. Miller to help you with your case?
I was trying to figure out today, sir.
Hold. Oh, there goes the TV. There goes everything. All right.
It's being overworked.
Apparently. Everything just. Something that felt like a transformer, just like boom. Oh, you still there?
Oh, look at that.
Sorry, we had a power surge, sir. So you said you wanted to plea out today, is that right?
I got a family, sir. I got another month-old son who's waiting for me, and I have a job. So I've been at the job for 2 years, and
well, let me do this. State, would the plea offer today result in Mr. Gutierrez's release?
Yes, Judge, as long as there isn't anything else holding him.
Well, hold on, sir. I have to hear from the state attorney. So he would be able to be released. There is a pending charge, I believe.
Yes, he has a pending felony case, Your Honor. So.
Oh. Well, Mr. Gutierrez, would you like to have a lawyer to talk to about all this before you decide to enter a plea to this charge? If you cannot get Mr. Miller right now because you're in custody, I can, if you ask, we can work on getting the public defender appointed to help you. Yes, ma'am.
He's got the public defender on his felony case. He filled out an application and qualified.
Sir, I can appoint the public defender and I can see you tomorrow at the same time after you have a lawyer appointed to this case. Would you like me to do that? I can't hear you guys.
You know what, Judge? It actually says this.
yes, Your Honor.
Okay, hold on.
The application is on the file.
Mm-hmm.
It has both cases on it, but I guess they just file it in the case.
All right, let's. Yep. So let's appoint public defender on this case, sir. I will see you tomorrow at 2:15. I'll make sure that your lawyer is present so we can talk to her about that and figure out what to do. Okay.
Okay, thank you.
Thank you, sir. See you tomorrow at 2:15.
Is there a public defender in the courtroom still?
No, she had left.
Thank you, NJC.
You want to maybe send a quick email to Ms. Woodley letting her know that I appointed her on this case?
Is that who your public defender is?
Yeah.
Okay, because I was going to email her the offer too. Okay.
Yeah, it's Ms. Woodley. I'd appreciate that, and that way she can hopefully have a chat with him when she does her initial stuff with the coffee. All right, I think we're done. Thank you.
All right, sorry, Judge, I was typing.